Hi, everyone. Welcome to the training. This is the COB portion of the training out of the series. If you give me a moment, I do have one screen, so I will be able to take questions. However, I can't see the questions during the Q&A, so I will pause in between sections to then go into the Q&A to answer any questions. So please post your questions there so I can see them. At this time, before I get started, are there any questions? Can everyone hear me? Okay. Okay, I will start if there's no questions. Okay, court order benefits, the virtual training. So today we're going to discuss former spouse benefits under the civil service retirement system, which we affectionately call CSRS, the federal employee retirement system FERS, the health benefits program, FEHB, FEGLI, and then we'll discuss a few more at the bottom, but our core will be on the CSRS and FERS. So just a little bit of background. We received new regulations on court orders from Title V in 1992 regarding Title V CFR Part 838. This is the regulation in which all of our orders are guided under. We did publish a handbook for attorneys for court order retirement so that they have an understanding of what we're looking for, what will be acceptable, what will be denied. We also, in this same handbook, discuss different types of awards, whether that be a survivor annuity or an apportionment, different calculations. We also try to stress this as much as possible. OPM's role is ministerial, and what that essentially means is whatever's in that court order is what we go by. A lot of times we'll get clients that will contact us and say, well, I want to do this and I want to do that. The only way that we can change what we do is if you elect to do something that grants that former spouse more, or we have to get an amended order. We do not mediate in between parties, whether that be between attorneys, between former spouses, new spouse, old spouse, etc. What benefits can be affected by a court order? So the first thing is a divorce or separation. Let me explain a divorce or separation. Divorce meaning anything that states a divorce decree, a marriage of dissolution, a judgment of dissolution, anything that separates the parties and no longer state that they are one or a union. The same thing happens for separation. They can't simply say in a mediation document, oh yeah, now we're separated, we've been living apart. No, it has to be a document of legal separation. And in these documents, it will divide the retirement system. So it can divide the CSRS and FERS annuities. You can do refunds, or you can do a FERS employee contribution. You can also, provide a survivor annuity to a former spouse, which is payable upon death of the employee or retiree. And this is also basic employee death benefits, but that's only under FERS. You also can permit the continuation of coverage under the health benefits program for a former spouse. You can require an employee to cover their children under the health benefits. You'll see this a lot of times within the parenting agreement or parenting plan that sometimes may be included in court orders. You can also require that an employee or a retiree assign their life insurance coverage to a former spouse or children and or a dependent. We also, within our division in COB here, also discuss benefits for garnishments. These garnishments are particular to only these cases that you see listed, which are alimony, child support, child abuse cases, and Chapter 3 bankruptcies. All garnishments require an income withholding order, also known as an IWO. It cannot be a letter. And in this IWO, it has to come from the court. It has to direct us to pay. And two caveats. The first caveat is, in order for us to pay out, meaning OPM out of COB, to pay out of these garnishments, the person has to be a retiree. They have to be an annuitant. If the person is still employed by your agency, we then redirect the court to say you need to send this IWO to the specific agency for which that person is currently employed. Now, there are some benefits that cannot change or be affected by a court order, and that's the FEHB. So your dental and vision plans, we cannot essentially require an enrollment for FEHB to cover the children. We also cannot make the former spouse a qualified relative for federal long-term care insurance. Okay, so at this time, I'm going to pause just to see if there's any questions regarding that. And it looks like I don't have any questions at this time. Oh, someone asked, what is my name? My name is Olympia Oliver. I apologize if I did not give that to you before. Someone also asked, do you have to submit a divorce decree if divorced before your federal career? And I'm going to publish this question and submit a reply in the chat. The answer to that is, if there's any type of divorce that may award a former spouse that is qualified to receive a part of your annuity is any spouse that was married during the time of your federal career. So what that also includes is credible service. So let me explain. If you have prior military service before your federal career, your military service will be credited into your total service time. So if, say, for example, you have a former spouse in which you were married and divorced only during your military career, which occurred before your federal, if that divorce decree awards a part of that, that will be your total service. Now, that divorce decree will also have to specify, because if we're talking about military, we also have to differentiate between DFAS, which is the military retirement. So you have to be specific in your court order when you say your federal retirement versus your military retirement, but just know that you do have portions of time where it's a credible service. If that question seemed to be too convoluted of an answer, I will give you guys my email address and you can email me and I can give it to you specifics and give you regulation. So if you guys are ready, my email address is Olympia, OLYMPIA .Oliver, OLIVER @OPM.gov. Okay, so someone else asked, what do I do in court order benefits branch? I am what they call a paralegal specialist. I review all court orders. I do garnishments. I calculate former spouse apportionments. I also review cases. We also go through health benefits information to verify that. We do work hand in hand with the legal administrative specialists that also finalize annuities. Let's see. I said garnishments, court order. We do a little bit of everything. So if I didn't answer that, there's more that I can give you. Yes. It says, could I get a link to your portal for registration? I need to get slideshows for the portal. I cannot find the link for them. Miss Patricia will be the one to kind of help you with that. And I see a lot of people asking about the slides, and it says the slides are not showing. I want to make sure that they are showing. Employees can give us the court orders. Just know that there are 3 parts that you have to be very familiar with when you discuss or you send in your order. It has to be the divorce decree document. Then if there's a separation agreement that's outside of that, a lot of times this will have happened between the parties before the divorce is final. We will need that. And then if there's a qualified domestic relations order or a court order that's acceptable for processing, we'll need all 3. If a court order does not specify anything for the divorce decree for retirement, we still need that document. We need to have verification that that former spouse is not awarded anything. So that way, if that former spouse contacts us on her own or on his own, we have the documentation that says, I'm sorry, you didn't get anything. If there was something that you wanted to change, you need to go back and get an amended order. Yes, I will be showing the slides. I will go back to the presentation momentarily. I just wanted to answer a few questions. There isn't a regular hotline, or shall I say, to answer questions, but I did provide my email address. I will publish that in the chat as well. So if you have other questions, you can email me. If you were separated when hired by then you get divorced, you have to pay any retirement. Okay, so again, your separation has to be legal separation, and then a divorce. So it depends on when the court order is dated. My email address is Olympia, OLYMPIA .Oliver, OLIVER @OPM.gov. Okay, I'm going to go back to the presentation at this time. Please definitely keep your questions coming. Portion. Okay, so we cannot pay out any apportionments or any awards until we receive the documentation. So that's up to the annuitant. That's also up to the former spouse. There is a separate former spouse application that a former spouse can submit in order to receive those benefits. The employee, at the time that they retire, we require that they submit all divorce decrees, all documentations, everything, even if there was a former spouse that they had that passed away or was deceased prior to their retirement. We need to make sure that A, she didn't get an apportionment once they were divorced, and B, that upon her passing or his or her passing, that those or her share does not go to any other beneficiaries, such as children of the marriage. Yes, we can accept legal separation documents to remove a spouse. It does not have to be a legal divorce. But I would also definitely check with your health benefits. And when I say health benefits, I mean like whether that be your plan, Blue Cross Blue Shield or anything like that. Okay, I'm going to go back to the presentation. I want to keep it moving. I know that we are on a time frame. So please hold any other questions and I will come back. Okay, so requirements for a court order acceptable for processing. 1, the order must specify whether it is a CSRS or FERS. It must identify the retirement. 2, it must expressly state that the former spouse is entitled to a portion of the annuity or refund. 3, it must direct OPM to pay the former spouse directly, or it can be silent. Please note that if your order says the employee or retiree will pay the former spouse until OPM pays, that is fine, but it still needs to specifically state that OPM will directly pay the former spouse. It must provide sufficient instructions and information for OPM to compute the amount of the former spouse's share of the employee annuity or refund. For example, because we are dealing with all 50 states and territories, the order, when it divides or awards the former spouse's share, it must be in terms in which that are known to us, that we can communicate. It cannot be a state formula, meaning sometimes you'll have, according to Leesburg formula in the state of, for example, Wisconsin. No, we cannot have that. It has to specifically outline the formula. For example, if it's a pro rata, it should state it should be 50% times the total service during the marriage from May 5th, 1984 to January 8th, 2012, divided by the total service for the annuity. That is a specific and very detailed formula that we can use to compute. It cannot be a state statute. In the case of a portion of the employee annuity, it must specify the annuity for the application for the percentage or the fraction. For example, is it going to be the gross, which is the annuity that is reduced for survivor benefit? Is it the self-only, which is the unreduced annuity, or is it the net annuity? The net annuity is the annuity after all deductions have come out, after your health benefits, after the life insurance, after all of your deductions have come out, the net annuity is what remains. The order can also give a specific amount or a set amount. We also call that a lump sum. If it does that, a set amount or a lump sum, please know that your cost of living allowances are not automatically applied. The order must expressly state that the former spouse is awarded a survivor annuity or direct an employee or annuitant to elect to provide a former spouse survivor annuity. If the order is silent on that, we will not award the survivor annuity. However, there is an exception. The exception is that if the court order does not award a survivor annuity, but the retiree or annuitant, when they submit their application for immediate retirement, if they elect to provide the former spouse a survivor annuity, we will honor that as well. It must provide specific instructions on how to compute the amount for the former spouse survivor annuity. This is the same thing that I was discussing when we talked about a pro rata formula. It also must be issued to the date of retirement or prior to the date of retirement or death, whichever is earlier. This is a very, very crucial point of information. Let me be specific when I say this. If you are divorced and your order awards a survivor annuity, we must, and when I say we must acknowledge that prior to your retirement. If, for example, the divorce decree does not award a survivor annuity, and you go back and later amend that, we cannot take an amended order for a survivor annuity. We can only take an amended order for apportionment purposes only after retirement. Retirement is that magic date which ceases to allow a former spouse to have a survivor annuity. That's why it's very important that if you want them to have one, that they are elected one at retirement, even if it's not in the order. If you have intentions to go back and amend that order. Okay, so it also says, do the same rules that apply to private sector employees apply to federal employees and retirees? The answer is no. For those of you that are familiar with ERISA, which is the Employee Retirement Income Security Act, ERISA is what governs private sector employees. This is separate from the FERS and FERS. FERS and FERS is guided strictly by Title V CFR Part 838 and USC Section 8467. Okay, so FERS and FERS government plans are exempt from the ERISA laws. Okay, it also says the parties must be sure, the person who is drafting the court order, that it is intended to affect the FERS and FERS. That's why it's important that in that order, it has to identify the retirement annuity. It can't just say, well, they all have retirement plans, and then start going into the division. We need to be specific. Court orders affecting the health benefits are also governed by Part 890, Title V of the CFR. Court orders affecting FEGLI, which is the life insurance, are governed by Title V CFR Part 870. Court orders that are used to divide private sector plans are called quadros, Qualified Domestic Relations Order. You'll see it also as QDROs. Let me say this. You can get a quadro, which will have ERISA language, and that is for a private sector employee. If the document says quadro, but then it says reviewed and administered under the terminology of Title V, Section 838 of the CFR, we will accept that. So as long as it has that Title V CFR 838 language in it, we will accept it, even though the document states Qualified Domestic Relations Order. Okay, so it says, where do employees find the rules that apply? CSRS is in the USC, FERS is in the USC, different sections though, 8401, 8445, 8467, 8470. Both CSRS and FERS is in Title V of the CFR Part 838, and then former spouses is in the USC Title V, but it's Section 890 and 8905. The handbook that I mentioned or referenced earlier, there'll be a link to that. Copy that link down, and all of this information is provided in that handbook. It says, where do attorneys find, this is the second part of that slide, and then it's the assignments of the life insurance, court orders and beneficiaries, and garnishments. So this is everything that you see that says USC is the United States Code, and then anything that's CFR is the Code of Federal Regulations. Okay, this is the link that I was talking about. It said these provisions of law, along with the retirement health insurance and life insurance regulations, are contained in, which is a 38-116, a handbook for the attorneys on court-ordered retirement health benefits and life insurance under the CSRS and FERS programs, the FEGLI and the health benefits program. Please copy this link down. This link is the key. It will answer a lot of questions that you will have, even some that you may have after this PowerPoint. This pamphlet also gives you how to do the different formulas in regards to computing specific retirement benefits, that are to award an apportionment to the former spouse, or if you have specific questions about the survivor annuities, that link is there. I will see if I can copy the link and put it in the chat as well. Okay, before we get into TSP, because this is a little different, I will pause again momentarily to take questions. Okay, I have not discussed the FERS annuity supplement yet. I will get to that though. And yes, I am going to follow the PowerPoint slides. I am going over them. I have added, as I'm talking, more information than what's on the slides. If you have questions about that, please let me know. Okay, so in regards to the health benefits, a former spouse is entitled to health benefits after they are divorced. And depending on what their order says, the order can state, hey, they must provide insurance, or the former spouse can go through, because they are awarded a portion of the retirement annuity, or they are court ordered to have those health benefits covered, they can go through and get those benefit service. There's a link that I will show you further. I'll probably put that in the chat as well. Both of those links, one for the handbook and one for the former spouses. So that way you can see there's a whole website for information for health benefits. It says I have a qualified federal retirement court order filed with OPM. My former spouse has retired. Okay, so this is something I really want to clarify. When a person retires, they must retire with their agency first. Then that retirement packet is then sent to OPM to process the retirement. Their retirement packet, once it reaches OPM, has to then go through different phases to make sure each part of the retirement is processed accurately and timely for it to all come together. When it comes to COB, the court ordered benefits portion, we cannot pay a former spouse before paying the annuitant. The annuitant's case must be finalized and active before it can then be processed for a former spouse apportionment. So, to answer the question specifically, everything depends on a timeline. If we don't have everything we need, that takes time. Meaning if we don't have all of the orders, if we don't have the settlement agreements, if we don't have the co-ops, if we don't have everything, that takes time. If the case goes to where we don't have all of the credible service history, meaning the military retirement, if there have been refunds or contributions that were paid out prior to retirement that may or may not affect a divorce, we need to know about that. If there's an opportunity where the annuitant wants to pay their deposits or redeposit so that they get more credible service, that also affects the time. There's a lot of moving and working parts. So one case, somebody may retire in March, and then they may have their first full annuity payment by September. However, Most cases, it takes at least 6 to 9 months at a minimum to process a case all the way through for them to go ahead and receive their full annuity. In the meantime, in the interim, they will be on partial pay, but we move as fast as we can. However, one particular part or element stacks upon another. So everything builds to where they have their full amount. I did put my email in the chat. So okay. It says no slides. Okay, so to clarify on your application, for the survivor annuity, if there's a specific dollar amount that you want to be awarded, you can write that in, even though it states a percentage of the base. But please note, if there's a court order that exists that awards more than what the annuitant or employee is electing, we will go with what the court order will award. Yes, you can email me to see if there is an order on file. For specifics, just so that in the best interest of time, if you have questions about a specific scenario or a specific situation, please feel free to email me. That'll kind of cut down some of the questions because I'm trying to read and present at the same time. Thank you guys for your help. You would really have to call. The only other thing that you can do is we do have an email address. It's retire@opm.gov. You can use that email address to then verify if there's a divorce decree. The other thing is to, unfortunately, call. There's a 1-800 number. I will get that and put that in the chat as well, but you can call that line and that information will then be told to you. Please know that it's often busy. At a last resort, you can email me. It says the link to attorney's handbook says page not found. Okay, I will address that. Okay, momentarily, let me put in the information in the chat for those links. Okay. See if this will work. Okay. So I just put in the link in the chat to the handbook, and that link works. Well, it worked for me, so somebody try it and tell me if it doesn't work. Okay, and this is the link for the former spouses. So I just provided you guys with 2 links, and hopefully that will work out. Let's see. Okay, the link works. The link works. Thank you guys so much. Please try also the health benefits link and let me know that that works too. I want to make sure you guys have everything you need. No, OPM is always receiving mail for original stamp documents. We actually prefer it. It definitely makes the approval process. All documents must be court certified with an impressed seal from the court and an original wet ink seal, a wet ink signature from the court clerk. So that's how we know that these documents are court certified. Okay, so it seems like everything is working. I'm going to go back to the presentation. Again, if you guys have questions, just keep them coming. Yes, 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 yes. I did say, the question is, did you say that OPM wants all divorce decrees, even if it doesn't leave anything to an ex-spouse with regards to retirement or a retiree or employee death? Yes. Answer is yes. And I'm going to publish that question too, just so everybody can see. That is important. That allows us as OPM to go, okay, even though we recognize that there's a former spouse that did exist, we know that that former spouse is not awarded anything. Okay, so I'm going back to the presentation. It says, how can an employee find out if a former spouse remarries and is not eligible for the annuity awarded in the court order? Okay, so the only way to essentially find out if a former spouse is remarried is to find out what county that marriage occurred in. Anything that is a marriage record, a death certificate, birth certificate, all of those should be registered with the Vital Records Department for that county. So including your marriage license. So that's where you would find out if a former spouse has remarried. I apologize. I will start repeating the questions that I'm answering. And so with this one, it said, how can an employee find out if a former spouse remarries and is not eligible for the annuity awarded in the court order? Again, they must find out where the remarriage occurred and in what county that it occurred in. That way you can get verification of the marriage license. The question is, how long does it usually take to adjudicate the court-ordered portion after the rest of the retirement has been adjudicated? So essentially, it doesn't work that way. Before the retirement can be finalized, we have to verify, because in the finalization of the retirement, it also will deduct the court-awarded apportionment. It also will divvy out or explain the former spouse survivor annuity. Many times you'll have a former spouse that's in the past, but then the annuitant is currently married. And so we have to make sure it's first in time, and then the current spouse will get essentially the remainder of the survivor annuity that's left. Okay, so I will go back to the presentation. If you have questions, just let me know. Yes, we need all documents in their entirety. The question was, do you need all pages of the divorce decree? Yes, we need all pages of the divorce decree. Even if it's 71 pages, we need every last page. Same thing for the settlement or the property settlement agreements or the separation agreements, whatever they may be called. And the same thing for, of course, the qualified domestic relations order or the court order acceptable for processing, which we call the co-op. We have to have a certified copy. It cannot be a regular boilerplate copy. And the question was, can a copy of the divorce decree be sent, or do you need to have, can a copy of the divorce decree be sent, or do you have to send in a certified copy? We must have a certified copy. Also, please make sure that the version that is sent in is signed by the judge. If it is not signed by the judge, it happens. I don't know how it happens, but there are some times that we will get certified orders that are not signed by the judge. They must be signed by the judge. Even if most judges nowadays, due to COVID, do have electronic stamps or electronic signatures, that is perfectly fine, but it must be something that indicates that the judge has signed and approved it, and it is a formal order. Okay, back to the presentation. Okay, so where do attorneys find the rules that apply to court orders affecting TSP and military retirement? First and foremost, I want to say that COB, Court Order Benefits Branch, does not process orders that affect the Thrift Savings Plan, known as TSP, or the military retirement, which is DFAS. Those regulations are in CFR Part 1650, Subparts G and I. You can go to the TSP website for more information. That is a different agency altogether. You can have court orders or divorce decrees that award apportionments from both parts, meaning they will award a part from the Thrift Savings Plan, and then they will also award a part from the FERS or CSRS. This is, again, another reason why we say that the orders need to be specific, because if it just says retirement and you know that there's military retirement or you know that there's a TSP, we don't know which one. So that will get denied and sent back. For the military retirement, DFAS is the agency responsible for that, and you will have to call and contact them. Please note that if your order awards a portion of a TSP or a military retirement, again, I'm saying this again, we will deny it and send it back if it does not specify the annuity, meaning CSRS or FERS. Okay, what can a court order require from the annuity? It can require that an apportionment divide a CSRS or FERS benefit as a result of the divorce, the legal separation, or an annulment of marriage. Again, we talked about it expressly directing OPM to pay. It can require the payments to a former spouse from retiree's annuity during the retiree's lifetime. Please note that if an order states that a former spouse is to receive an annuity or an apportionment payment for the duration of the former spouse's lifetime, it will be denied. We can only pay an apportionment from a retiree's annuity during the retiree's lifetime. Okay, survivor benefits. It says payments to the former spouse that began after the death of the annuitant. Those are what those survivor benefits. Sometimes in an order, you'll see a post-survivor benefit and then a pre-survivor benefit. So all of that, we are looking at the post-survivor benefit. This is the one that began after the death of the annuitant. Refund of contributions. A court order may provide that all or part of a refund of an employee retirement contributions be paid to a former spouse. Please note that when we pay out a contribution, we pay those in an installment. We will not pay out a large sum or a large chunk of money at one time. For example, we will not pay out $26,000 at one time. It will be paid in installments. A court order also may block a payment of a refund. It may state OPM is not to pay the annuitant or the employee a portion of the refund or contribution. It can also grant the survivor annuity a portion of the retiree to a legally separated former spouse. So remember when I was speaking earlier about how the shares can be computed? The shares can be in 3 different ways. So it's a fixed amount, a percentage or a fraction, and then you can also do lump sums. Like you have a fixed amount that's this fixed amount for an entire time, or you can do a lump sum payment in which we pay out in installments. However, the amount cannot exceed the amount payable to the retiree after deductions, taxes, and insurance. So that amount that we're talking about, it cannot exceed the amount payable. We're talking about the net annuity. It cannot exceed the net annuity. When can a court order terminate a benefit? So an amended court order can terminate an apportioned benefit that was in a previous order. So the rules of orders go with last in time is what trumps. So if you get an order that was dated in 2012, but then we get an amended order that comes through that's 2018, we will go with the order that's in 2018. A court order is also required to terminate benefits to the former spouse that are payable to the former spouse's estate, the fiduciary of a court, or surviving children of a marriage. So, for example, if the former spouse becomes deceased, and they state that the payments are to resume and continue, but be paid to the former spouse's estate, or to a fiduciary, or to the surviving children of a marriage, we can do that as well. An amended court order prior to retirement or death can terminate the award of a survivor benefit. However, amended orders are not acceptable for terminating a survivor benefit after retirement. Again, your retirement date is that magical date that changes everything. We can do anything prior to retirement. We can terminate a survivor award. We can give a survivor award. We can do all of that. But once you retire, we cannot terminate it. Okay? The only way that we can terminate an award is if you were married prior to retirement and then you divorced after retirement. And at that divorce, the divorce decree does not award a survivor benefit. Then we can terminate that survivor if you get divorced after retirement. Okay, how can survivor benefits be provided for a former spouse? Monthly survivor annuity may be payable after the death of an employee, or that's via the court order, or you can do the survivor election. This is when an employee basically voluntarily elects on the application for immediate retirement when they elect for their former spouse to receive an annuity. I'm sorry, there's one part at the bottom. It says if the employee has remarried, this election may be made only if the current spouse consents to it. So if you are, I don't know how many of you guys have a copy of the application for immediate retirement, but if you go through the pages, it'll show where there's a portion you can elect a former spouse survivor annuity, and then there's, I think on the very last page, a portion where it states the current spouse consents and they must sign and have that part notarized. So that's where that consent comes in. It says, can survivor benefits be, survivor benefits provided? A court order survivor annuity is not available unless the marriage lasted 9 months. Entitled to a former spouse survivor annuity ends if the former spouse remarries before age 55, unless the employee and the former spouse were married for 30 years or longer. Now, there was a question that was presented earlier that was asked regarding how do you find out if a former spouse has remarried. You go to that county in which that marriage occurred and get a copy of the marriage license. We cannot terminate a survivor annuity based on remarriage without having the marriage license of the former spouse that indicates that she's married to someone else now and she's younger than the age 55. Okay, if an employee dies, a court-ordered survivor benefit is payable to a former spouse if the employee completed at least 18 months of credible service, credible civilian service, and dies while under CSRS or FERS coverage. Under CSRS, a survivor annuity is payable. Under FERS, a survivor annuity and the basic employee death benefit. Now that is a lump sum, it's payable if the employee has 10 years of credible service. Okay, so a separated former employee. So under CSRS, no former spouse survivor annuity is payable unless the employee died after age 62 and after filing an application for retirement benefits. Under FERS, a former spouse survivor annuity is payable if the annuitant has title to a deferred annuity. The basic employee death benefit is also payable if not expressly excluded in the court order. So if it's silent, it will be payable. But if the order states that the basic employee death benefit is excluded, it is expressly stated this is to not be included, then we won't do it. Okay, so it says what amount of the survivor benefit can be awarded for CSRS. Under CSRS, the maximum combined total is 55% of the unreduced annuity. And so in this line, it says combined total of the current and former spouse survivor annuity. So here's an example. If David married Susan, and Susan and David then get a divorce, and she's court ordered the max. Well, David has now remarried. Well, his current spouse will not get a portion of the survivor annuity because the former spouse is awarded the max. Now, say for example, David and Susan divorced, and she was awarded a portion or a pro rata share of the survivor annuity. The former spouse will get her pay of the pro rata annuity, the pro rata share first, and then the current spouse will get whatever's left over. Okay. A court order awarding the maximum survivor annuity to a former spouse reduces the survivor benefit that can be paid to the spouse married to the annuitant at the time of death. That is the example that I just gave. Okay, the maximum amount under a FERS is 50% of the unreduced annuity. A court order awarding a survivor annuity to a former spouse reduces the max that can be paid to the spouse married to the annuitant at the time of death. So, for example, it goes the same way with FERS. Again, David and Susan were married. They got divorced. She got awarded the max under FERS. The current spouse that David has will not get any. If at the time they got divorced, Susan was only awarded a partial survivor annuity, then whatever's left of the partial survivor annuity from the 50%, then that is what the current spouse will receive. Okay. Insurable interest of survivor elections. An employee who is in good health can make an insurable interest survivor election at retirement to provide a current or former spouse with additional survivor benefits. Disability retirees are not able to elect an insurable interest. Okay, so restrictions on modification of court order survivor benefits after retirement. It is very important that provisions intended to award a survivor annuity both reflect the intent of the parties and conform to laws and regulations. Again, we cannot assume. There's something that you hear people say called the four corners of the document. We can only go by what is written on paper to know the intent of the parties. We cannot assume. Court orders affecting survivor benefits can be modified only prior to retirement or death. Once you retire, again, I keep stressing this, that's why it keeps coming up in the slides. Court orders cannot be modified to affect the survivor benefit after the employee retires or they pass. Okay, before we get into the application of benefits, I'm going to see if there's any questions about this, and this will be a short break. Okay. It says, the question is, does submitting a divorce decree slow the process in the event that nothing is awarded to a former spouse? On the contrary, it actually speeds it up. Now we don't have to stop and ask or stop to contact the annuitant to then find out if there is an order or what happened or anything. We don't have to wait. It actually speeds it up. I'm going to put that answer in the chat as well. Okay. Then it says, it was always my understanding that if divorced, an annuitant does not have to provide a divorce decree, in particular, if the next is not allowed any money. I understand that. I understand people are very particular. They want to keep their business to themselves. However, in this case, when they retire, by law, if a court order exists in which they are required to provide a former spouse an apportionment or survivor annuity, we must have that order. And when they're not, we also need that order. Many times, I hate to say it, many times people do not part on amicable terms. So you will have spouses that fight even after divorce, even after the order says what it says. One party won't agree, another party will say this. We can't trust that. We have to go by what is on record and what is filed. So again, as I stated before, even if there's nothing that is awarded to that former spouse still has every right to call us and say, hey, I'm supposed to get an apportionment of John's retirement annuity. And so we go and we look it up and it's like, oh, well, we never got this order. And she's like, yeah, we can't just take her word for it. We have to have an order that states, no, Crystal does not have an apportionment awarded from John's annuity. And so it helps to have all of those documents and records on file so that when she calls, we can say, I'm sorry, ma'am, Miss Crystal, you don't get anything. Additionally, it also helps because of that whole retirement being the magic date. When they retire, we cannot change for survivor benefit. So if, say, they retire in June, and then we get a court order that comes in July that says, oh, well, let's go back to David and Susan. So say David has divorced Susan and David is now married. Well, he filed for retirement in January. We didn't get his court order regarding Susan until June. We cannot go back and give her that former spouse survivor annuity. But at that point, OPM is wrong. Then we get a lawsuit and it becomes a very litigious issue. We cannot. That's why we expressly state there's a former spouse, even though there is no court awarded money or a survivor annuity, we must have the document that says that. It will prevent a lot of other issues further down the line, and it also does speed up the retirement process. The question is, how does OPM contact the former spouse to let them know that they're going to receive a portion of the retirement? And then it's a two-part question. Then it says, what if the former spouse has moved since the court order was filed? So in regards to a former spouse, we do send out letters. Once that person has retired, we have the order. We do send out letters to the last address on file. Now that order should, those letters should then get forwarded to the new address that the former spouse left. But it's ultimately the former spouse's responsibility to contact OPM and keep an updated address on file with us. We will at times reach out to the annuitant to say, hey, there's an apportionment that your former spouse is awarded. We can't reach them. Can you have them contact us? Or can you provide us with contact information? It says another question. We have been told if a divorce decree is included, the retiree will receive a smaller interim payment until the legal team has reviewed the divorce decree to determine nothing is owed. Only then will the retiree receive a reimbursement, hence a delay. Okay, so anytime that a retiree retires, okay, and they have to process the order, they go into interim pay. So it's going to be interim pay. Now, the reduced portion is when it comes to the former spouse survivor annuity. We would rather have it to where we have that time to review the order and we process it immediately. That's why it's important that we have the orders up front. So when they submit that application packet, the application for immediate retirement packet, when they submit that and we have those orders, sometimes the case file doesn't even have to come to COB. If we can see that the orders are there, it doesn't award a survivor annuity, then it can go on to finalization. However, when it doesn't, then we have to reduce that pay until we can finalize it just to verify that there's no former spouse annuity award, but we need the court orders to do that. So it takes time to get the orders, then it takes time to review them and then have that done. So again, by law, we cannot withhold that survivor annuity award if it is court ordered to that former spouse. So that's where you're quote unquote seeing that delay. If we don't hold it and, if the funds, say for example, we pay out too much money to the annuitant because we did hold it or we didn't hold it rather, in this case, let me be clear. If we pay out too much money to the annuitant because we did not hold their case file for the reduced portion and it comes back after the finalization of their retirement that we didn't hold enough money, we will then have to deduct from them even more money than what his normal deductions would be. What we're trying to do in this process is to ensure that once the case is finalized for retirement, that the retirees can basically live in a good retirement and they can plan out the rest of their lives. We don't want to have to go through the back and forth of, okay, now you were paid too much, so now you got to pay this back. Oh, now this has to be adjusted, so now we have to change this money on this end. We don't want to change the money and we don't want to go back and forth. We want it to be set. So once it's finalized, and then that's done. So if something changes, it's only changing because they changed their health benefits, or there's an amended order that comes in. We don't want to change it because of errors or mistakes. That's why we withhold so much, to make sure that, hey, this is finalized, we got the right orders, this is the right amount that he's supposed to receive. We don't want to have to pay out more up front and then have to turn around and collect that on the rear end. The question is, we have found that when a retirement goes through the court order branch, it can cause significant delays in processing the retirement. If we send out court orders, even when they do not award a benefit to a former spouse, does OPM foresee that affecting timeliness, and how can we justify that to our employees? Okay, so there is a process that we have in the COD branch that's called the pre-screen process. So when an application for immediate retirement is put together and those court orders are included in that packet, it's all in the file and it gets screened. So there are times where those cases do not even come to COD. So I can't speak for what happens for the duration of the packets leaving the agency and getting to OPM before they get to finalization. I can't speak to that process, but I can say that if it comes to COB and it's got a court order, it immediately gets screened and it gets sent on to finalization. It does not stay in our unit long. I will also tell you this, that you can, at the time that, so say for example, you have an employee knows that they want to retire in June, and this is January. You can tell them, if they have their orders and they're already certified, you can tell them to send them into COBI at the time in January before, so that way they can actually get an approval or denial letter about their orders early, and then that way they have time to plan. So that way, by the time they do have their retirement, we already have their orders on file. Now, that also means that we may have their orders on file. Please do not hesitate to include an additional copy of those orders in that packet, just so that way we can say, yep, we got this, it's good to go, and we can keep processing it. The more orders we have, the better. Another question is, will the retirement applications be updated to say all court orders need to be sent regardless of apportionment? We are working on that with management to modify and change the application. Yes, that should be coming down the pipeline. It is in the works. Okay, so there's another question that says the best way to gain a copy of the divorce decree. The best way is to go to the court in the county in which that divorce decree was filed, and you have to talk to the court clerk about obtaining that copy. Now, various courts, various counties, everybody has a different fee for getting a copy. In some cases or instances, it may also be the fee may increase to get a certified copy. So you have to contact that court in that county. Okay, so I think I just answered that question. The question was, when should employees submit their court order? Are they supposed to wait until retirement? No, you can, and I'll put this in the chat as well. No, once you divorce, you can send in all your certified orders then and be okay. I will say this, when you send in your certified orders, if your divorce decree states a court order acceptable for processing or a quadro will be completed to effectuate the division of the retirement, your application will be denied because we need that quadro or that co-op. So you will need to submit all the documents together for review before you can get a possible approval. And so what I mean is, if you have your divorce decree, then if you have the settlement agreement, if it's not incorporated, or meaning in the text of the divorce decree, and then you'll need the quadro or the co-op. You need all three of those documents inside of one submission packet when you submit your court orders for COB to review for you to get your approval or denial letter. Okay. So this is a scenario question. Again, I think I stated this earlier. If you have specific scenarios or questions like that, email me. It'll be easier for me to respond in that manner. I'm going to go ahead and read this one. This one seems to be a little simple. It says, if Karen gets the max but then dies and the retiree initialed, he wanted to give it all to his current spouse, then I believe his current spouse would get it because he indicated that's what he really wanted. We have them complete the application as if the ex wasn't around, so the current. Okay, so in this scenario that's given as the question, I'll go back to David and Susan. I think that's who I used before. So if David divorced Susan, okay, and he now has remarried and has a current spouse, at the time that David and Susan divorced, Susan was only awarded a partial. Well, if Susan dies and the divorce decree states that upon her death, everything reverts back to the employee, or even if it is silent on what happens after she passes, then it'll all revert back to the employee. So then if he elected for his current spouse to get the max, then yes, she will get the max. However, if, say, for example, the former spouse dies, and when she deceases, the former spouse was awarded the max, then what will happen is that max will just, his annuity will still continue to be reduced for the max, but then it'll go to the former spouse. It'll be the apportionment that if the order says goes to her estate or the surviving children, it'll be the apportionment amount that goes to those children. Okay. Okay, so there was another question that says, how would you know what county they remarried in if you don't keep in touch with them? If there were no kids and no contact with anyone related to the ex-spouse? Unfortunately, that's one when you may have to hire an investigator, or you may have to, there's a legal service. If you talk to an attorney about the situation, called LexisNexis or Westlaw, where you may have to research and find out where they're located. If there wasn't a court order benefit awarded, does OPM still need an original, or can you then send in a copy? We will always need, that was the question. So this question pertains into sending in the divorce decree and the documents. We will always need a court certified copy. No matter if there's an award or no award, it will always need to be a court certified copy. There was a question here that says BEDB. I'm sorry, I'm not familiar with that term, so I don't know what that is. And yes, I did say pro rata. Pro rata is a type of apportionment in which it is essentially 50%. This is when you're computing the apportionment amount, the formula is called a pro rata. And the formula is 50% times a fraction, the numerator of which is the time of service during the marriage divided by the total time of service. And then take that amount times whether that be the net annuity or the gross annuity or the unreduced annuity. That whole formula is what we call the pro rata. A marriage license or a marriage certificate just states that the ceremony was performed. A marriage license means that it was actually put on file at the county. In some states, a marriage certificate and a marriage license are the same thing. So whichever you can get that is a verified document that can be court certified that the marriage occurred is what we need. The question was, so a marriage license is sufficient proof, you don't need a marriage certificate. And that's what I just explained. So the question is, if ex-spouse does not file the divorce decree with OPM and they weren't getting anything anyway, would OPM hold up the retirement finalization? How would OPM know? Only if the person's name changed would there be any possible red flag? Not exactly. We go through every document that is sent in your application packet. So we go through your pay cards. We go through all of your life insurance documents. We go through your health benefits documents. And these are ones that have also been filed over years and over time. So it's not just about a name change. We look at the persons in your family, the births of children, the deaths of children, anybody that you have tied to you to receive any of your benefits or has been listed under any benefits that you receive. We look at all of those documents. So it's not just if someone's name changed, it can be a complete change in record. So especially we see a lot of times where there are single persons who upon their passing, when they first get hired, they're like, oh, in the event that I pass, give it to my mom or my sister. And then they get married and it's like, okay, give it to my wife or then give it to my children. And then in some cases, they're still married to their wives, but they decide to leave all of it to their children. So we see the change over time. So it's not just because of name change. We look at all of the documents together. Okay, it says, the question is, to my understanding, a divorce decree is not mandatory to include the retirement package if it doesn't leave anything to an ex-spouse with regards to retirement. The retirement application only said to include the divorce decree who awards the survivor annuity. Yes, I understand that. We are working to actually change the application retirement package. I said this on numerous occasions during this presentation. I can't stress it enough that even if there is no award, we must have those orders. It will delay the process if we do not have those orders. We cannot go on an annuitant's word alone that there is no award. We must have verification and documentation that says that there is no award or that the order is silent on the award. And we must have all of the documents in their entirety. So if it's 25 pages, we need all 25 pages. If the document is 70 pages, we need all 70 pages. The question is, how soon should a person send their divorce decree when a spouse is not entitled to anything? If a person has 7 years to retire, when should the person send the divorce decree? As soon as the divorce decree is final, they can send it immediately in. Once it's final, signed, sealed, and delivered, if you have that certified copy, you can send it in. Hey, I want to put this on file. Please scan this in to my file. My former spouse does not get anything. OPM will review the order. We'll see what that says, and we'll send you a letter that documents what we have and what we know. Okay, it says, what is the process for submitting a pre-approval request for COB? Again, you would have to submit in court certified documents, meaning that they have to have an impressed or raised seal from the court with a color ink stamp on it. So there's two different types of seal. Let me clarify that. There's one seal that's impressed, that's raised. You can rub your fingers on the paper and you can feel that seal. There's another stamp that can be given that has the court seal on it. That's an ink stamp that is actually signed by the court clerk. Okay, both of those versions of the court seal have to contain a signature from the court clerk that says, yes, I verify that this is a true an original copy. Okay, the court order needs to be court certified, and if there's a quadro or co-op, it needs to be court certified. The settlement agreement, if the settlement agreement is merged into the divorce decree, it does not need to be court certified. However, if the settlement agreement is a separate entity or a separate document than itself, then it needs to be certified. So there was another question that says, should we not estimate the division of the benefits between spouses or the quote unquote present value of an employee annuity, which must be determined by a private actuary? That question is a slippery slope. My best answer to this would be if there's a court order that effectuates a division of the annuity, it would be best to get a pre-approval letter from COB for that court order to see if it's approved. If it's approved by COB, COB will tell you how much the annuity should be reduced by. And then at that time, I would go ahead and see about doing an estimate of the division or the present value. Okay. I'm going to get back to the presentation. Again, if you have specific questions, I did provide my email address in the chat, so definitely feel free to email me. Let me get back to the presentation. Okay, so application for benefits. A former spouse must apply in writing to be eligible for a court-awarded portion of an employee's annuity. Again, there is an application for court-ordered benefits for a former spouse. If you don't have this application, email me and I can send you a copy. I don't have a link for that, so that's the only reason why, but I do have a copy. So if you email me, I can send that to you. It says, unless a court order is already on file at OPM, the application letter must be accompanied by a court-certified copy of the order. Exactly as what I was explaining. There is no special form required. The letter must request payment from the employer retiree's retirement benefit. It has to have all those documents. We did just discuss the certification. Now, for a former spouse, when they send in this application, we must have all of the information to identify them. So even if the employee sends in the orders, they need to be able to identify the former spouse. We need their name, we need date of birth, we need social security numbers, and we also need the same information for the retiree or the annuitant so that we can link them together, so that we know that this former spouse is applying for benefits from this employee or retiree. When a court order is subject to termination upon remarriage, no payment can be made without a further statement that a remarriage has not occurred. This is again why we also ask for the marriage license, so that we can verify that yes, there is no there is no remarriage. Remember, there was a question that was presented to me earlier in which they asked, how do we know if a divorce decree is on file with OPM? This is our court order benefits information line. You can dial that line. It's 1-888-767-6738. When you get ready to submit your court certified original copies and documents, please mail them to this address, which is OPM Retirement Services at P.O. Box 17, DC 20044-0017. Okay. If I need to put that in the chat, I can put that in the chat as well. Okay, so the role of OPM. I've stated this before, OPM's role is ministerial. We simply authorize the payments. Again, it has to be clear, it has to be specific. We cannot have any state statutes in the order that require us to interpret them. We will not do so. Again, I don't know So again, the way that it works is federal regulations trump state regulations. And so we need the order to be written where it effectuates and applies to a federal regulation and not state statutes. If the order is not acceptable, the parties must return to the state court and get an amended order. That's the only way we can change or do anything. So it says to claim court order benefits from OPM, the former spouse or legal representative is responsible for. They have to file that certified copy. They have to keep us advised of their current mailing addresses of both the former spouse who is claiming the benefits and the retiree and those who are being affected. They must notify OPM of any changes in circumstances that could affect the entitlement of the benefits, such as remarriage. That's what we were talking about. Submitting all disputes with the employee/retiree to the appropriate state court for resolution. Again, if the former spouse submits an application, we read the order and we're like, okay, it's approved and these are the terms. The employee then retires and we send him the same letter that says, okay, per your court order, this is what it is. And if they disagree with it and we have been found to be right, in regards to the application of what the court order says, it will be between the former spouse and the retiree to then go to court to get an amended order to change it. We will not do any changes just because the two do not agree. Upon determining that a court order is acceptable, OPM will inform the former spouse, their attorney, the retiree. We will inform both attorneys. The date on which the spousal benefits are to begin and the month of the benefit or the formula used to compute it. Again, if there's disputes, and I just talked about this, if there's disagreements with the determination of the calculation. Now, if there's a disagreement with the determination of the calculations, we can ask for a clarifying court order that may be able to change it, or if the former spouse and the annuitant agree that the court order is correct, but then there's an error on OPM's end with the calculation, we do give reconsideration rights, which then it goes to our legal reconsideration unit, who will then review OPM's calculations out of Cobb, review Cobb's calculations rather, and then send information to the annuitant and the former spouse. So this is where that process is when an individual contests the validity or the amount. So an amended order that invalidates an order that OPM has already processed should be sent to OPM as soon as possible. So in the event you send your order early, so say in 2012, I'm gonna go back to David and Susan. So say in 2012, David divorces Susan, but David doesn't retire until 2020. Well, in 2018, there was an order filed in the court that changed the division or changed or amended or modified the original divorce decree from David and Susan. Then we need a copy of that 2018 order. So now we're talking about garnishments. Okay, so I'm gonna switch up here. Garnishments are basically a legal process under state law that enforces legal obligations. Garnishments are typically seen in child custody cases, or if there's a divorce and the person is ordered a garnishment of wages for child support. So you'll see them for alimony, child support in cases of child abuse and Chapter 13 bankruptcy. It must conform to state law requirements involving private employers. Limitations on the amount. An individual who has remarried and who is supporting a current spouse, dependent child, or the child other than the awarded child support, the child awarded child support may be garnished up to 50% of their disposable income, or 55% if the garnishment for support payments is at least 3 months in arrears. So we will not exceed the net in any way. An individual who is not remarried or supporting another child other than the child awarded may be garnished up to 60% of their disposable income or 65% if they're at least 3 months in the arrears. The disposable annuity is the annuity that is paid after deducting from the gross any debt owed by the retiree to the U.S., health benefits, life insurance, Medicare premiums, amounts payable to another person based on the child support or based on the court order for child support, or any property withheld in federal, state, or local income tax. So your disposable annuity is also essentially the net annuity. Again, it didn't state this at the beginning of the garnishment section. Garnishments that come through COB, we only do them and basically pay out or process that IWO, the income withholding order, if that employee is now a retiree, if that person is then still employed by the agency, we deny that income withholding order and send it back to the court for them to then send it to the agency. It said, with whom should a garnishment order be filed? For retirees, they come to us through that same mailbox, the P.O. Box 17. For employees, just as I stated before, the order should be sent to the employing agency. For health benefits eligibility, a former spouse was awarded a portion of the CSRS and FERS annuity or a survivor annuity by a qualifying court order, even though the benefit is not yet payable, meaning if you submit your orders early before they retire, right? You cannot get your portion of the annuity until the employee retires. But say you submit, or the orders are submitted early, meaning that he's still employed by the agency, the former spouse is still eligible to enroll for health benefits coverage under the Federal Employee Health Benefits Program, okay? The former spouse is not eligible to retain coverage under the employee's family enrollment. So that has to be separate. That's where they must be removed from that family plan. I think that speaks to a question that was posed earlier. Okay, so the temporary continuation of coverage. If there's a former spouse that doesn't qualify for the health benefits, then they can get, or excuse me, they may apply for TCC. That's kind of like a conversion. A former spouse who loses coverage may convert from the may convert to a non-health benefits program. So that link that I sent, that's in the chat box, it actually goes further in depth into this, and it all applies to the former spouses. Again, there's a former spouse attorney handbook. If you go towards the back of that handbook, it also talks about survivor annuities and their awards, and it also talks about health benefits. Okay, so a former spouse is not eligible for FEHB. Even if the court order gives them eligibility, a court order cannot require an agency to enroll employee or annuity in FEHB to cover their children, even if they refuse to do so. So the Federal Employees Health Benefits Children's Equity Act of 2000 only applies to the Federal Employee Health Benefit Program. Okay, so the long-term care insurance, former spouses cannot apply for this. A former spouse is not a qualified relative to be able to enroll and apply for the long-term care insurance. A court order cannot also require them to be eligible or apply, or allow them to apply or enroll. Now, enrollment, if they are previously enrolled, then they can continue their coverage, but a court order can't require them to have new coverage. So if they are a former spouse who is already enrolled as a qualified relative, meaning they were enrolled prior to divorce, so their status was different then they can keep it. But you can subsequently lose your qualified status upon divorce as long as the carrier receives the required premium when due. So you have to go back to the long-term care insurance programs and see who's a qualified relative for them to see if you will be able to maintain coverage or if you will lose coverage. Because here it says upon divorce, it can change. So I apologize, I misspoke in my previous statement, I was saying that if they were a current spouse, they can continue. But no, it's if they divorce, they can lose their status as a qualified relative. So please just check the long-term care insurance program and see what a qualified relative is before you let them know whether they can continue their coverage or not. Okay, life insurance. So as of October 3rd, 94, it allows employees or retirees to assign their life insurance coverage to another person, a firm, or a trust. The person who makes the assignment no longer has control over the insurance coverage. It can no longer designate beneficiaries. An assignment is irrevocable and applies to your basic option A and option B insurance. So a court order may require the assignment of life insurance benefits to a former spouse or children. The employee or retiree, not the employing agency or OPM, must execute the proper form. So the form is the 7610, which is the assignment of the FEGLI. So again, in your retirement package with the application for retirement, sometimes you do have persons to submit these forms as well. So a court order versus the order of precedence, effective July 22, 1998. This requires that provisions of a court decree of divorce, annulment, or legal separation, or terms of a court order or court-approved property settlement agreement relating to the decree be followed instead of the statutory order of precedence for payment and benefits. So essentially, it's no longer what was first, it's based on what the court order says. So if you have an amended court order, then it goes by the amended court orders, whatever is effectuated in the court that is out of the certified order. For the statutory provision to apply, a certified copy of the order must be received in the appropriate office on or after July 22nd, 1998, and before the death of the insured individual. So again, it just changes that they go by only the court orders. And remember, the rule with court orders is last in time is the one that is applied. So if you have an amended order, that amended order will be what goes. So the proper filing for life insurance documents for active employees, the appropriate office is the employing agency. For annuitants, it's the OPM. During the first 12 months of non-pay status, the appropriate office is the employing agency. After separation or completion of 12 months in non-pay status, the appropriate office is OPM. Just to be on the safe side, I would do both and then check just to see and make sure that they're processed appropriately. A court certified copy of the court order is required at the employing agency or at OPM. Designations of beneficiary for life insurance and retirement contributions. A divorce does not affect a designation of a beneficiary that was filed at an earlier time. An employee or retiree who has designated a now former spouse to receive life insurance or retirement lump sum benefits must file a new designation to name a different beneficiary. So designations of a beneficiary may be changed at any time unless there's a court order in effect. So if in your court order it says you have to designate so-and-so, so-and-so, then you need a court order to change it. But if your court order is silent on any designations of beneficiaries, then you can fill out the form and change them how you see fit. So what is the role of the employee's agency? The employee agency is a proper source of employment and pay information about service with that agency during divorce. OPM does not receive records until after they separate from employment. So after the employee retires with the agency, then we receive the packet for their retirement. If the employee had previous employment in a different federal agency, information about contributions to the retirement fund during earlier services available from OPM. So for clarification, say you have an employee that at one point was with the DOJ, and then at another point they were with the DOD, And then at another point, they ended up at DOI, Department of Interior. So when they retire, we will get all of the service and all of the information from all three agencies at OPM. And then that's when we can see everything as one big picture. But if it's something that they need, so say they were married the entire time at the DOJ and DOD, but then they're getting divorced and they're still active at the DOI, then they need to talk to the DOI about payment and what's going on with their benefits regarding that divorce during the time that they're still employed. Requested information, the agency can provide in response to a subpoena signed by a judge or release signed by the employee. It includes a statement of the retirement system coverage, the amount of money withheld by the agency to the employee's credit in the retirement fund, and the annuity estimate using the service to date. So I think this speaks to a question that was posed earlier when they were asking about when is it safe to make the estimations. If you have two parties that are in the process of getting divorced and they need all of this information to then put it all in terms of the divorce decree, go ahead and give those estimates. But if there is a retiree that is if there's an employee that is getting ready to retire and they're asking about an estimation of funds and you know that there's a divorce decree, I would definitely try to get that divorce decree approved by OPM, so then that way you can give them a more accurate estimation of what their annuity will be. What is the role of the employee's agency continued? It says agencies can prepare estimates of benefits the employee has already earned. However, an employee agency cannot determine the proper division of benefits between spouses or the present value of an employee annuity, which must be determined by a private actuary. So again, that's why I gave the statement that I did before, is that you would really need to have the documentation of that approval from OPM regarding that court order if you were to attempt to do this. I don't recommend it because you don't want them assuming one thing and then everything comes back to us and they're like, well, wait, I was told it would be this number. I wouldn't do it. I would calculate what your estimate is and say, but hey, you do have this former spouse, you do have this court order, so it's going to change because they have to apply this court order. This is what your quote unquote present value would be prior to the apportionment being calculated for your former spouse. Agencies do not provide estimates that involve speculation or attempt to advise an employee, spouse, and attorney about how to draft a court order. That's what the handbook is for. If you have an employee that comes to you and they're like, well, what does it need to say regarding my annuity, or how do I do this? You can definitely give them a copy of the handbook or refer them to that link. We do not give pre-approvals based on drafts. The order must be court certified before we can give an approval or denial. The employee agency handles health insurance enrollments for former spouses and receives premiums as well as assignments of life insurance an employee may make. Okay, so it says, how can agencies assist OPM? Employees should not complete the voluntary election with the former spouse's information unless they truly intend to voluntarily elect a survivor benefit. This goes back to the whole retirement. That retirement is a magic date. If you are still with this spouse and you like, hey, this is my spouse, this is my woman for life, I want her to have a survivor benefit, then okay, do it. But if you have a former spouse and you're like, I'm not sure, I don't know if I really want to do that, I may or I may not. Remember, this is, if you really want to do it, okay, and do the election. Now, if there's a court order, then there's a court order, okay? Now, if you are in a situation where you like, I don't know if I'm really going to stay married to this person. Our marriage is on the rocks. I don't want to do a survivor election, okay? Or I don't want to do a former spouse survivor election. please note that once you retire, you cannot change it. Okay, so if you do your application for immediate retirement and she is your current spouse at that time and they sign the consent and they notarize it to state that there is not a survivor election done, then you cannot go back after your retirement to then change it and give them one. So please be aware of that. It says agencies can advise employees to provide complete court-certified documents to OPM immediately after divorce and again to their employing agency at the time of retirement. Again, I was talking about the divorce decree, the property settlement agreement, marriage certificates, and those quadros are the co-ops. So it says notify employees that they should expect retirement processing times to be approximately 6 months if a court order is involved. So again, I was saying 6 to 9 months, and please let them know that it is 6 to 9 months after they have retired with the agency and closed out with the agency and OPM receives it. So I hate to say this, but the mail is a big issue in this situation. If you retire, say you retire from DOI in January, and you're like, okay, so 6 months from January, so by July, everything should be done. Well, if OPM did not get those orders until March, you need to do 6 months from March. So it needs to be 6 months, not like I said, 6 to 9 months from the date of OPM receiving it, not just from the date that they retire from the agency. Okay, our customer service representatives are available. Now, this says federal work days from 7:30 a.m. to 7:45 p.m. Eastern time. My biggest thing that I would tell you is everything's by email. Given the COVID pandemic, we are still on maximum telework status, so they're only in the office 2 days out of a week. So I would definitely, if you call, you can leave a message, but I would definitely do the email route. Okay, for more information, you can go to www.opm.gov/retire. If you have further questions, I'm going to exit out of this and take questions. So we have a few more minutes left for questions. And let's see. So there's a question that says, how does the beneficiary form fit into this? The beneficiary form may be something where they're court ordered to have a former spouse as a beneficiary. So that was just to highlight and let them know that when they submit those beneficiary forms, they will go based off what the court order says and what's elected. They'll look at them together. It says, question, will OPM send back the certified divorce decree once OPM scans it into their system? No, we do not. We actually keep that hard copy on file. There's a question. If the former spouse remarried prior to age 55, is a copy of their marriage license sufficient to prove no court order benefit is payable? Yes, a marriage license is sufficient. Yes. It says, can we save this presentation / Q&A portion? I am not 100% on that. I think you can, but you have to go through your functions in Teams to do that. I am not a Teams expert, so you might have to ask somebody. But if you have questions after or later, you can definitely email me. There's another question. If a court-certified court order, etc., are already on file with COP, can a photocopy be submitted with the retirement package? Yes, but I would be careful with that. If you submit a photocopy with the retirement package, I would send the COB approval letter. So let me explain. If there's a court order, etc., that is on file with OPM and it was approved by OPM, we will then mail the employee a letter. Once they receive that letter, when they get ready to retire, I would attach a copy of that and then the approval letter. And then that way you can send a photocopy if you want to. On any other circumstance, I would always send a court certified copy. Oh, this is a long question. Okay, so the question is, can you provide an average number of court orders that OPM currently receives and processes? I'm thinking that if all court orders are provided, including those that award no benefits, the number that OPM receives from all agencies will rise exponentially. There are many employees who have divorces before becoming a federal employee, and some who have 2+ prior marriages or court orders that do not award benefits. I'm just concerned about the processing times at OPM, as most cases with court orders that our agency has submitted with timely submissions by the agency were delayed by several months. And OPM's retirement branch response to us is that it is with the court order branch for review. Okay. So I cannot provide an average number of court orders that OPM currently receives and processes. And the reason why I say that is because I specified earlier, we have a complete team that does what we call a pre-screen. So there are cases that are identified where there's a potential former spouse or the case has court orders. They'll come to us. We will scan it. If we scan it and see that there's no award because the orders are there, we immediately kick it to finalization. It doesn't stay in our branch, not even a week. They're in and out, okay? Now, if there is a packet there's a case file we receive and it indicates that there are former spouses and we don't have the orders, those we have to develop to actually get the orders to find out if there is an award or if there is not an award. That's why I would reiterate what I stated earlier. It is very, very important to send an order regardless if there is an award or if there is not an award, because if we have to develop, it takes longer. So the process to develop, we give you guys 30 days to get it to us. So that's 30 days that we have delayed the processing of your retirement because we need these orders. So, and sometimes, especially if it's somebody that divorces early in their 20s and then they don't retire to their 60s, they may or may not have a copy of that order on file with them. So then they have to go to a court, track down the copy of that divorce decree, and then they have to try to make sure it's certified and then get everything back. It is always, always best practice. It doesn't matter. Send the court order in, even if it does not award anything. Okay. And yes, we do process a lot of orders, but with our screening process that has been implemented, we actually get out faster those that we already have the documents for. So if you send your retirement packet and those documents are already included, we can scan it and get it right on out of there. It says, will OPM post a training OPM's official YouTube channel? I'm not sure about that. I'm not in control of the training. I'm just doing the presentation. Can the former spouse send us the divorce decree to have it uploaded in the employees? Sure, they can. If the agency reaches out to do that, to get it in the EOPF, if you want to upload a copy of that, that's perfectly fine as well. But it still needs to make sure that it's court certified. I would, even if you uploaded it, I would still send a court certified copy with the retirement package if you choose to go that route. Let's see. Is it sufficient if the court order states a fixed annual amount to be paid to the former spouse out of the employee's annuity? Will OPM just divide by 12? It's possible, but then that's a speculation. We do have senior staff that will approve if it's an unconventional computation. So it just kind of depends on what the seniors and management will approve if that is a scenario. Okay. Thank you for saying that I was correct with that statement. I wondered about that, but I was like, I don't want to deviate from the slide. Thank you. I will make that change in the slide. It said I was correct with the first statement saying that a former spouse can keep the LTC coverage for the premium, because the slide said that they would lose it if they weren't, but it said that they could keep it. It says, how can we be expected to provide an annuity estimate for someone who is not eligible to retire for many more years? There are some agencies that do what they call kind of like career planning, in which you can go to HR and it says that if you stay with the agency and you put in this amount of money, say if you put in this into your TSP and then we contribute this much, by the time you retire in 20 years, you'll have this amount of money. So I think those are the estimates that they're talking about early on. And then there are some that are those that are getting to retire sooner rather than later. And so those that are retiring sooner rather than later, those are people who plan to retire in a year, 2 years, 5 years. So then it says there's no guarantee that an employee who is not currently eligible to retire will ever be eligible. They may leave federal service. It seems very important to provide an estimate of annuity for divorce when there is no current retirement eligibility. I can't speak to that question. That may be one that you could email OPM send the email to retire@opm.gov, and we might have to send that one to upper management. I'm not sure about that one. This is the last question. It is 3 p.m. So I will take this last question and then we will close out. Again, you have my email address if there's any questions. It says the handbook states it is not appropriate for attorneys or agency personnel to attempt a present value, correct? Also, agencies should not attempt to determine the proper division, correct? Such computations, correct? And it says such computations of the total actuarial value of the retirement benefits require application of various economic and mortality assumptions that are beyond the scope of the employing agencies or OPM's responsibility. This is correct. This is why I said I personally would not do it. However, if you want to state that, based on what I see, if you have these deductions, then you're possibly looking at this amount of money. But I would always say on a contingency, this is subject to this division, taxes, et cetera, Social Security, everything. I would not give a complete or a firm number. That just is a setup. Again, thank you guys for your time. Thank you for your attention to my presentation. If you have any questions, my email address is in the chat. Feel free to email me. Have a good afternoon, and I wish you guys all the best. Good luck.